everyone. My name is Marcio Kotz. I'm the Chief Operation Officer for GetPrivacy International, and we are here today for another episode of our Data Privacy podcast. I have the pleasure to have here with me my co-host, Jennifer. How are you today?
Good. How are you?
Good. I'm doing great. And today we're going to talk about the new piece of legislation, the data protection law in India. And we have also the pleasure to be with Raktima. How are you today, Raktima?
Hi, I'm Raktima. I'm great. How are you?
Okay. My first question, because before we start talking about the new data protection law in India, I usually ask our guests to talk a little bit about themselves so we can understand how they got involved into this data privacy world. Get Global International is all about data privacy around the world. So it's always nice to get to know people from different places. I'm from Brazil. I'm a European lawyer, but I'm based in the US. Jennifer is a data privacy lawyer living in Texas right now, right, Jennifer?
Yeah, licensed in Colorado, New York, and Texas. Yeah.
And she also has a very strong knowledge of the GDPR, of the European General Data Protection Regulation. So we would love to hear a little bit about yourself.
Thank you so much. Well, I got into the data privacy space more than 7 years back now. I started off as a global, WTO lawyer, and at a time when GDPR, right before GDPR had come into force, and when EU was at the WTO pushing for global data privacy regimes. And I later shifted to one of India's biggest law firms, where I was a senior associate. And I recently left that to pursue my second law degree at Georgetown Law, which I completed last month. So when I was in India, that was the time, 2017 to now 2023 has been a period of great immense activity around the data protection law in India. It started off with this expert committee that was set up by the government after the court recognized a right to privacy and told the government that you need to put in place a regime on data privacy. So at that time, this expert committee came up with some recommendations around what the law would look like. And then we have had different versions of the law in 2018, 2019, 2022, so essentially almost every year since then. And it has undergone different iterations. And finally, it got passed, last month. So it's a moment that we all have been waiting for, and we are very excited about it.
Yeah, very good. I read an article. I think you were the author of that article, and you cover, the whole data protection law. And I felt by reading that article that this new data protection law in India, it has a GDPR flavor, but a lot of things, it seems to be, unique compared to the standards that we are used to work with. I usually say that until this new data protection law in India, we had, let's say, 3 different standards in the world. One is the European GDPR that some countries, they follow this standard. The American standard, the US, which is more sectorial and not just not one comprehensive legislation, and China, that's totally different. It has its own standard. But how would you classify this new data protection law in India?
Right. So I think, first of all, that approach in general is changing because there have been so many new privacy laws, even within the US. There have been I think, close to 12 privacy laws in the past couple of years. So I think it is time for companies to sort of realize that an approach where you're simply dividing up, by jurisdiction like that might not entirely work, because many jurisdictions are in fact taking very different approaches, which is a strong argument for like global harmonization on this area. I would say though, if I had to compare with the three regimes that you mentioned, I would say it's a combination of what the EU is doing to some extent and what the US has done before this flurry of privacy laws. So the reason I'm saying that is because it is a law that has overarching application across different sectors. Definition of personal data, the grounds on which you can process that data, how do you collect consent for that data, whether or not there will be any cross-border restrictions of that data, all of that is covered in this law. Having said that, the law does clearly specify that the specific sectoral regulations that are currently in place governing, say, financial data or telecom data, those will still remain. Mm-hmm. So we have data localization requirements under the financial sector regime, and that's something that's going to remain even after this law comes into force. So I would say that in that way, it is more similar to GDPR for sure, but the sectoral approach is just inherently baked into how the Indian just field of law works. We have sectoral regulators for every sector, almost every sector that is regulated. Yeah.
Raktima, what do you think as far as the biggest change from, and I know enough about the Indian law to be dangerous, but what do you think will be the operational impact to companies doing business globally? For instance, like Coca-Cola, who has a global presence. What is going operationally? What is going to be the biggest oh my God moment for Coca-Cola when it comes to complying with India? Because from what I understand, the law has a much broader, even more so than GDPR, it has a broader impact across organizations.
Yeah, arguably. Both laws have extraterritorial application. It is true that the way the law is structured, if you have any operations in India, you have employees in India, you're processing any data, belonging to Indians. There is quite a bit of opportunity for the regulator to essentially come after you and say that you're covered by this law. Mm-hmm. And that is definitely something that global companies need to be consulting local experts on. There is an exception that they try to make for outsourcing, because India is a big outsourcing market. Right. They have tried to essentially say that if you are a data controller in another jurisdiction and you have a processor in India, and then you're exempt from most of the compliances associated with data controllers. But if you're compliant with GDPR, I would say your biggest, maybe what you said, like your oh my God moment might be if you're processing data, like the grounds of processing are much narrower than they are under GDPR. Okay. So that might be the biggest moment of challenge. The consent framework is similar. So if you're processing all of your data under the ground of consent, you might not face that many challenges. But if you are, say, relying on legitimate interests or contractual necessity, right, which are two common grounds that multinational companies do use under the GDPR, right, then that there's no corresponding provision in the Indian law. That would be a little challenging for businesses. So I would say that would be the biggest challenge. There aren't any restrictions on cross-border data flows in this particular draft of the law. Right. A lot has been left to delegated legislation. So the government will issue rules under the law, okay, and later specify if there are any restrictions or not. Gotcha. Which is, till that comes in, companies are safe for now. Yeah. Well, on the whole, they have tried to simplify compliance for companies, I would say. Yeah.
Right. Well, India is, I think, very sensitive to maintaining that continual flow of data and the continual flow of commerce in and out of India, given how the rest of the globe is between China and Russia having the issues that they have, the next, who's the next major power, and that is India. So that's a big opportunity when you listen to, how commerce is waning in China and their economy and how it's crumbling. There's a lot of other countries that can step into that gap and take a chance at filling that void. What you said as far as the more narrow basis for processing, there's a very large social media company that's getting hammered in the EU right now as far as using legitimate interest for basis of processing, especially in Ireland. Do you think Meta is going to face similar challenges in India given the narrow basis for processing there under the law?
I mean, I would I need to think about that. I don't want to discuss specific companies, especially companies that I might have represented in the past.
Oh, okay, gotcha.
So
My bad.
I would say though that it is definitely, any company that is operating in India, no matter how long they have been operating, would have to look at their data map afresh and think about what are the bases on which they can process data, definitely.
Right.
And yes, secondary uses of any kind do seem to be a little bit complicated. So that is something that companies will have to figure out.
Right.
Yeah, I couldn't agree more. I remember last week, we got an email from one of our clients. It's a software company based in California. And we got this email and they said, now there is this new data protection law in India. We need to appoint a DPO in India, and we got to do it fast. And I answered the email, are you guys worried about, having a DPO in India? You won't need it because they are operators. They are not data controllers. So, and even as far as I understood, under the India data protection law, not all controllers need to appoint a DPO. And I told him, you should be worried about legitimate interest because that's pretty much the legal base they use for what that specific software does. And I do agree. I think that's going to be the biggest challenge when it comes to doing business with India and processing personal information.
So if they are a processor, then, finding a ground for processing would be the controller's business, right? Like they would have to figure it out. If they are not a controller, then it's not on them to figure out what, if they're not determining the means and purposes of processing, then, it's not on them to figure that out. And if hypothetically they are the data controllers and they had some processor in India, then as I mentioned, there is an exemption. You are allowed to do that under contractual terms, subject to certain conditions being specified. But yes, to your other point, not everybody needs DPO in India. If you are designated as what the law calls a significant data fiduciary, which I think intends to capture some of the bigger players in the market, those would have to employ a data protection officer in India. They would have to have a bunch of other compliances like data protection impact assessments, data audits on a regular basis, etc. So the point of that is, of course, some of the bigger companies have often been able to tell the Indian government so far that, the main company is headquartered outside India and, you only have limited authority over us. And it has been kind of an important regulatory priority for the Indian government, which has been reflected in many laws. And this is just one of them. Over the last couple of years, there have been many other laws where they have essentially highlighted the importance of having somebody in India that they can hold accountable if something goes wrong. Now, naturally, this is more important for companies with a large presence, which have an impact on a larger body of people in India. It isn't necessarily worth the government's while to go after someone who has a very minimal presence. So, yeah. And that's the other thing I would say for Companies outside India, when the law does come into force, yeah, like enforcement will definitely depend quite a bit. This is just my perspective as someone who's practiced there for many years. Enforcement will definitely depend on like your footprint in the country. That is what we typically see.
Right.
Hmm. Yeah, just regarding that specific client, in certain situations, they are co-controllers. So that's why I mentioned
Then
that
yeah.
they should, be a little bit worried about legitimate interest. And that's something that I feel that might change in the future. I don't know if that would be possible under the India legal system, because I don't know if the reason why I have that opinion is the fact that I have helped the Brazilian government drafting the LGPD, and one of the things that I advocated so strongly was the legitimate interest, having the legitimate interest as a legal base, mostly because we work for companies in the digital economy. And I feel that it's quite difficult for any innovative company to process personal information just under the consent, because it's expensive to manage and it's a risk for the business, because if you ask for the consent, you might not get the consent, right? So I would love to hear your opinion on the fact that the India data protection law doesn't have legitimate interest as a legal base.
It's definitely complicated. And to your point of like advocating for that with the government, that is definitely something that has been a key part of what we people who represented the industry have advocated for, that these are common grounds, contractual necessity and legitimate interest. These are common grounds under laws like the GDPR, and we need something like this to do business in India. That has definitely been one of the common asks from businesses. Many of the things that businesses have asked for have in fact been incorporated, including don't have any data localization, which is something that has been incorporated as of now. But this is one thing that does not appear to have been incorporated. It seems that the government does want to emphasize consent as a primary ground and what they call legitimate uses as secondary grounds. And those legitimate uses could be anything from employment, mergers and acquisitions, government purposes, emergencies, etc. So if you can show that the data that you're processing is falls under any of those grounds, then that is something, then that's easier for you. But I mean, given based on what I know about how companies use legitimate purposes under GDPR, there is definitely nothing that is as broad as that. So the government also doesn't really leave open an opportunity to specify a completely new ground through rules. But depending on how these provisions are interpreted, we will see how things proceed. I mean, it is a common law jurisdiction. There will be a lot of interpretation of different provisions. So, yeah.
Well, that brings me to my question: is because you've practiced in India and watched the implementation of law by regulation, what do you think is the next step in this process for the Indian people and the Indian government as far as the regulations go? Do they typically narrow things? Do they typically, because in the United States, for instance, the FTC regulation around the legislation that enacted and gave the FTC powers, and then the FTC has come in and created a lot of regulation around that scope. But some of those regulations narrow and impose fines and add to those requirements of the actual act. So that's my question here is, I'm assuming I haven't read up enough on the Indian law, but I'm assuming that there will be an agency to enforce of the law. But as far as
Yes,
regulations,
I will. Yeah, I'm happy to take that. So I would it's a little different from the role that the FTC plays, say, in the enforcement of COPA or any of the other laws that
Right.
they're enforcing. What the law sets up is a data protection authority. It does have the power to enforce the law in that it is this adjudicatory authority. So the way it's set up is that if you are aggrieved by something that a company has done, you go to the grievance redressal system of that company, and then if that doesn't work, then you go to this board, the Data Protection Authority, which is a board. And then there is an appellate system from there, which is the Telecom Appellate Tribunal, which has now been given the power to hear appeals from this new board as well. So that is similar. They can pass, similar to FTC consent decrees or accept voluntary settlements. Those would be the similarities. In terms of differences, this body does not really, a lot of people are not calling it a regulator in a technical sense because it doesn't have the power to issue regulations.
Right.
So all of the rules, all of the subordinate legislation, I did mention that there is a lot that has been left to delegated legislation. That has been left to, again, be done by the central government. So the structure is that the government will be creating the rules,
Right.
and this independent body will simply be enforcing them. They don't appear to have any power to make regulations in their own merit, which
Right.
is fairly unusual in India, because usually laws like this would tend to have one provision that says power to make rules, which are rules that the central government would be making, and then another provision that says power to make regulations, which specifies what are the matters where the independent regulator can make their own regulations and clarify things. That power to make regulations, which did appear in some versions of the law before, is no longer there.
Okay.
That is a difference, yeah.
Okay, talking about differences, what else? I do know that the law has like different names for things that has a different name under the GDPR. So what could you mention as things that are going to be a little bit different between the GDPR and the India data protection law?
Well, two key ones I've already mentioned are grounds of processing and no restrictions similar to Article 45 and Article 46 in GDPR. So those are two big differences. Then there are few new concepts that the law introduces. I wouldn't really compare it to any other law specifically. I would say that those are things that are best understood.
What about data controller? Does it have the same name?
Yeah, same. The name is different, but the concept is essentially the same.
How is it called?
You are deciding the purpose and means of processing. You're called a controller under the GDPR and data fiduciary under the Indian law. A lot of people have speculated on. The idea of calling it a data fiduciary originally was in the first expert report all these years back was that you're a fiduciary because you're holding the data in trust on behalf of the data principal. That's what the data subject is called.
Right.
But
It
for
makes
all
sense.
practical purposes, there's no real difference between the controller processor subject structure that is there in GDPR. It is very similar in the Indian law, I would say, practically.
Yeah, I would mention one more thing that I feel it's a big difference. It seems that the India data protection law is just for the digital environment, right? Compared to the GDPR, it goes way beyond just the digital. Is that true?
Sorry, what do you mean by the digital environment?
What is the name of the law? Because when I read it, I'm not a specialist, but it
digital
seems that
personal data protection. Yeah.
It's just digital. So it seems that not all sort of personal information would be protected under that specific law.
Right, like not informal data collection. That's not. If you do take down data in hard copy, that's what you mean, and then you digitize that later, that would be covered definitely. But mass collection of data is typically done in a digitized formats. I think it will sort of end up covering most processing activities, except for very small everyday processing things.
Okay. And
So
how does the law deal with small business? Do they need to follow every single?
they can notify exemption. That is another interesting feature of this law. They can notify exemptions for any kind of data fiduciary. They have specifically mentioned that they can notify exemptions for startups. Some of the previous versions also had like sizes mentioned. Here, I think they have kept it a little bit broader and they will notify as needed. But coming back to your original question of things that are different or new or unique, there is the concept of consent managers who are aggregators, like third parties who will mediate the data sharing between a data principal and a data fiduciary, and they will not have access to the data themselves, but they will essentially tell on your behalf, will tell all the companies that you're interacting with what your preferences are in terms of what data you're agreeing to share for what purpose. So that's a little bit new. We don't know how it will work exactly. There are financial sector intermediaries who are very similar. They're called account aggregators. And we think that that is the model that this law will borrow from. And then there's another new thing, that is they have the power to tell companies to block access to any data from the public, or summon any data, essentially even going beyond the enforcement powers of the data protection board. Those are fairly new things. It also has duties for data principals, like if it's your data being collected in other laws, typically you don't have duties. This has duties for data subjects, and then you have penalties for violating those. Those are some fairly new features, I would say, that I have not typically seen in other laws.
Is the duty to one of the duties on the actual data subjects, like are they basically caretaking of your own data, or
that, and don't impersonate people, don't give fake data, those kinds of things.
Gotcha. So basically no fraud.
No fraud, yes.
No fraud.
There is also one similarity that I will point out with many global laws right now, including in the US, which is that they are emphasizing that child data should be treated differently and there should be verifiable parental consent for that. We don't know what that will look like. That is also something that will be notified by rules.
Yeah, well, I mean, FTC is still, the FTC here in the States is still battling that on basically a daily basis. It's the management of parental consent. There's a whole lot of back and forth, and I imagine India might pull from some of the experience here, at least. What kind of technology can you use to obtain that verifiable parental consent? Because it's the argument from the companies is that it's not effective, it's not efficient, it takes a lot of money to implement, and the argument from parents is, well, it's tough.
Yeah, I think it's a little more complicated than that. I mean, COSA, the first version of COSA was so widely criticized in the US because it says Kids Online Safety Act, but there were so many provisions there, especially on parental consent, that essentially created a surveillance kind of regime for kids. Even though the second version was a little bit better, there is still quite a bit of conflict, I think, in the US around it. And knowing what I do of India, it is fairly likely that some of the provisions will be similarly, intrusive and surveillance, because it is, as a society, does place a certain amount of premium on parental control over children's data, which is not necessarily always beneficial, but it is possible that happens. It is also possible that they create some kind of identity verification requirement, which they have done in some other laws. That obviously leads to more data collection, and it's more problematic. And interestingly, I was reading this update from the Australian government, which commissioned a study by their e-safety commissioner, this large-scale study where they consulted every kind of stakeholder possible about age verification and technologies around it. And it seemed like even the government is in agreement after seeing all the evidence that yes, maybe it is kind of complicated and hard to do in a privacy protecting way with the technology that exists today. I mean, I definitely hope that that technology comes into place very soon. And in the interim, I hope that the verifiable parental consent provision does not contain, some sort of very, very onerous pro-surveillance measures or any kind of identity verification or age verification, hopefully.
Yeah.
But I mean, that's just my personal opinion.
Yeah.
I know that parents have very different views on these things.
You would think that, you know, if we can synchronize rockets, we could figure out how to get verifiable parental consent. But, you know,
I don't even know if that would be a good
it's harder.
So many parents who, especially in India, you know, digital literacy is still fairly low, and children often understand technology at a level much better than their parents do.
Yeah.
I wish there was an easy answer to the question of child safety, which is obviously very, very complicated.
Yeah.
But many children are first generation literate people. They are the ones introducing phones and technology and learning English, things like that to their parents. So, you know, it's...
Yeah. I would argue in rural United States, the digital literacy and digital hygiene, God, I can't talk this morning, are both not, it's not that people don't want to know, it's just that they don't either take the time, or it's been made so easy to do whatever they're doing doing now anyway, that to relearn or educate themselves about what the consequences are, it's inconvenient. And that's one thing about the United States where I think we're going to have to learn how to deal with some level of inconvenience in order to make things a little bit safer until we find
of course.
Yeah,
of course, yes.
Yeah. What about international data transfer? How does the law regulate this issue?
As of right now, the law says that there are no restrictions on international data flows, which is, you know, good news for global companies. It definitely says that we can notify restrictions through rules, and it does not provide any criteria for how that will be done. So it could be, you know, all data going to China is now blocked, or something like all children's data will have to stay in India. All of those are possibilities because there are no guidelines saying that these are the parameters that will be considered before imposing a restriction. And the other thing that the law says, which I mentioned at the beginning of this chat, is that to the extent that there are sectoral restrictions that are already in place, like financial sector data has to be localized, those will remain, those will not change.
Okay.
Mm-hmm. Interesting.
Very
interesting. Because I'm thinking about like a different possibilities, and it seems that we'll have to wait until the Indian government, you know, regulate many different things.
Yes. And I think to bring this back to one of the questions that you asked before, and I think I missed that, what are the next steps, which is that the law has been passed, but it is not what we call in force yet. So it will come into force whenever it is notified. And the government can say that, okay, the first 5 provisions will come into force now, or there's this one chapter that will come into force now, and then other chapters will come into force later. That is completely a possibility. And then so that is the next step, provisions of the law coming into force, that is the next step. And then the step after that is rules being notified.
Oh, wow.
And we can obviously expect that one of the provisions of the law that will come into force sooner rather than later would be the ones relating to setting up the data protection board, because that is necessary for compliance and enforcement purposes.
Gotcha. I have been tracking the India law since 2018. No, 2019. Yeah, 19. Because it was right before COVID. And I remember thinking, well, when is it? And then I would check in, and then about, 18 months ago, I just gave up. So
yes, I also gave up and came to the US, but just kidding.
But how long? I mean, it's I don't know. In the U.S., you have certain states that move quite quickly, like Colorado. Their regulations are out, right? Whereas, for California, some of the regulations for the second half of CCPA aren't even enforced yet because they screwed up the date. But then, as far as India, I'm just wondering, given the track record of the law, as far as when the effective dates and the enforcement dates start to drop? Like, what is the expectation on that timeline, do you think?
That is really hard to say. The government has provided many statements saying that it'll happen soon.
Gotcha.
Of course, there are internal procedures and things to consider that we wouldn't necessarily have oversight over.
Gotcha.
Yeah.
It's a fun
Because
time.
I got to tell you, I know many different companies that are like expecting some
Yes, I think
regulation.
that's a good idea. I would say that's a good idea. If you are a company that's operating in India, I would say there's no point in simply waiting for things to come into force and rules to be notified. Yeah, that is important for specific compliances, like for example, verifiable parental consent. But one of the things that I saw with clients who especially don't consider themselves to be in the business of data assets, like companies that think of themselves, whose primary business is maybe something else, and data collection is kind of like ancillary to their business.
Right.
They might be collecting like huge amounts of data from their employees or vendors or anyone else for any purpose. Maybe it's a hospital that's collecting a lot of healthcare related information, So because they don't see themselves primarily as a tech business, often one of my experiences would be, even if I ask them a simple question like, so what kind of data are you collecting? What, if like, for example, for this law, you would need to know, in order to comply with the verifiable parental consent provision, you would need to know what child data you're collecting, right? In the previous version of the law, you needed to know what kind of sensitive categories of data you are collecting, which isn't there in this version of the law. So if you do not have a clear map of what kind of data am I collecting, what are the grounds, what are the reasons I'm using this data, what are the grounds of processing, that is something you can get started on right away. Like that's not something you wait for anything.
I think that's a great advice because the law is not enforceable. So now would be the right time to start.
Yeah, it takes longer than
data discovery and data mapping.
Definitely takes long. Yeah, and I would say the bigger tech companies, social media companies, etc., they usually have these things under control and are much better prepared because data is their primary business. I saw this more with companies that are obviously naturally, understandably more focused on what their core business is and have invested less in these kinds of things like figuring out the data map. For those companies, I think investing in figuring out these things would be now would be a good time.
Yeah. That's one of my favorite answers is if your client's a construction company or something like a plumbing company, oh, well, we don't have data. I'm like,
that is, yeah.
You don't have customers? But yeah.
It's such a common response, yes.
Yeah, people misunderstand even the definition of personal information.
Yes.
People think it's any information that identifies someone, and it's not that the right definition. It's any information related with an identified or identifiable person. That means that it's much more broader than just what could identify someone. Or
data that is maybe you have in like put together can identify someone even if independently.
Yeah, for sure. I have managed more than 200 different projects on building a data privacy compliance program. And I usually say that the consent would be my last choice, just because it's too expensive to manage and too risky. And under the GDPR, I would have 5 other legal bases to deal with. Under the Brazilian LGPD, 9 other legal bases. So we usually would go for the other ones, and the consent would be the last choice.
That is
it seems the strategy. Yeah, what's your opinion on that matter regarding what the India data protection law gives you as options?
So one of the good things that it does, I think, is that it addresses the issue of legacy collection of data. So if you've already collected data prior to the enforcement of this act, it lets you provide a notice to the data principal as soon as reasonably practicable. So it doesn't say that you have to stop processing that data, because that is a challenge that we did face with some of our clients when they would say, on the verge of getting acquired by maybe a company that needs to comply with GDPR. That is like for the first time when they would think about all of the data they already hold and then try to retroactively get consent, which is always complicated, difficult, expensive, borderline impossible because it takes time for people to even check, figure out how they're going to do that. So that is one good thing. So if you already have done that, then they give you some time, and you don't have to stop processing data in the meantime. But for companies that are collecting new data going forward, provision consent, and then there is provision called voluntary data sharing, which is that if the data principal is seeking out some service because of which you need to process some data, then that is something that is covered under the ground of voluntary data sharing, which could be read as a restricted or limited version of contractual necessity, but not like 100% the same. So that is something that could be considered by companies. And then obviously, depending on the sector that you're in, I mean, like I said, there's a different provision for employment purposes. That is one of the legitimate uses. So that can cover your employee data. Then if you are in the healthcare sector, a lot of the health-related exceptions might cover you. But for specific companies, like, I don't know, plumbing is an example that Jennifer mentioned. I don't think there are any big, large-scale plumbing companies I can think of, but yeah, those companies which don't have like an obvious ground that you can see in the legitimate uses clause, they would have to figure out consent on an ongoing basis, and it's a very case by case determination, I would say.
Yeah, that's in the United States. I mean, we have chains, like, I'm trying to think of, it's not a plumbing, but like there's a chain called Terminex, and they do pest control, and it's nationwide, and people buy franchises, and that's I'm sure there are commensurate types of chains and franchises in India, but that type of, when you have independent owners of those franchises and that company tries to push those requirements down, at least the United States, I think, at least, not that I've not worked for a company yet that manages those franchises, but I can't even imagine having to I mean, every single franchise, I guess, from the head office is considered their co-controllers. I would imagine that's how that works. But those central entities, if they are constantly collecting and sharing and managing that data from all the franchises around the United States, around India, then that, in my opinion, like that back and forth of data and managing that consent just becomes a virtual nightmare, because unless you've got data tracking at all those franchises, which I know in the United States doesn't happen, I mean, how do you even manage deleting the data, accounting for it, pulling it back out of the parent company?
I'm honestly not very familiar with the franchisee structure. I was trying to, when you were saying all of this, I was trying to remember if I've ever worked with a franchisee. Yeah. I don't think I have. I think whether or not it is a data controller or a processor, it really depends on like the relationship between those companies and the parent company.
Yeah, it's definitely case by case.
Yeah,
because sometimes the franchisee, they have the power to decide what kind of marketing strategy they're going to have. Sometimes it's centralized. Sometimes they do things together, so they exchange personal information. We have a client. At the beginning, I thought they were a very big hotel chain, but at the end of the day, their business model is they don't own the hotels. It's just the brands. Therefore, the investor operates the hotel, but under their brand. So that's really tricky, because under most data protection regulations, the brand is going to be the data controller and responsible.
Yeah,
At
I guess
least
it
when,
depends on, sometimes you just like license the brand name from somebody and then you're
yeah,
doing everything on your
it
own.
depends. But
Yeah.
in Europe and some other countries, when you say protection, it means protection, right? So what I mean by that is that in the US, you still have what in Latin you call pacta sunt servanda. It means if it's signed, that's exactly what's going to be enforceable. In some other
Mm.
countries, when I mean protection, I'm going to protect the individual. So if I need to give an interpretation, if that brand would or not be responsible, they
Mm.
definitely would go for the big brand, and the companies would have to deal between them at the end of the day in order to find who is going to pay for that fine or things like that. So uh, on the practical side, you need to be sure that each hotel that's operating under your brand
Right.
is compliant with the regulation, because you don't and it's not just a fine, it's your brand. So if you see from the trust perspective that you don't want any kind of damage in your biggest asset, which is your brand, you
Right.
need to be sure that each hotel is compliant with the regulation. And when it comes to a hotel, you are going to get guests from everywhere, right? Especially if you are in New York, California, London, everywhere, big cities. So that's one of the trickiest projects that I have worked with. Um, it's complicated to manage this whole thing, but it's doable. But it's not easy, definitely.
I have a quick question, Raktima. As far as the public response to the ability to manage your or have some sort of say in the use of your data, was there a push by the people of India to have this in place? Is this something that they wanted and that's why
Definitely.
very much so?
Yes, it's coming in the hills of a lot of discussion around this, and um, companies, civil society, I think everyone has been on the same page, and the government. They have all been on the same page about the need for data protection law. The disagreement has been more about the content. And now that the law has come, not come into force, but now the law has passed, the response seems to be that, well, it's good that we have something, but at least the public response has been that there are too many broad exemptions. The government essentially has retained a lot of power to notify different things, and there are too many exemptions for government purposes, which means that it's providing you some degree of protection against corporate misuse of data, but not so much against government misuse of data, which has been one of the biggest criticisms of this law in every version of the law that has existed. And unfortunately, it has not progressively gotten better. So that is the public response, I would say. From a corporate perspective, again, I would say that apart from the grounds of processing, the rest of it isn't that is better than many of the previous versions from a corporate perspective, because some intermediate versions used to have like criminal liability, personal liability, and like complete localization of some data that just cannot go out under any circumstances, not even be processed outside or stored
Right.
outside, etc. Those things are gone, so that's a positive step for companies. Just like the processing, I think, would be a big challenge. That's the general response, I think, to the law.
Okay, perfect. Almost 50 minutes of conversation. It goes fast. It was great stuff. I learned a lot. So thank you so much for sharing with us, all the knowledge you have. And I'm pretty much sure that you're going to be busy, in the next years for sure, because a lot of work, a lot of opportunities. So thank you so much for sharing with us.
Yeah, thank you so much for the invitation. It's great to be here.
Same. Very nice to meet you.
So thank you, guys. As I said before, this episode is going to be uploaded on podcast, and our next episode will probably be about the Chinese data protection law. That's going to be very interesting because it seems that the data privacy around the world is, getting a shape, and it's interesting for international data privacy professionals to deal with the different legislations in different parts of the world, especially working for international companies. Of course, we can't be, specialized in every single legislation. That's just impossible. But Get Global has the pleasure to have professionals in different parts of the world, and bring them to the podcast is also a pleasure. So thank you so much, and see you next time. Bye bye.